questions or today, but I wanted to do a quick live stream because what has been transpiring here in the United States of America recently, as that pertains to those in civil service making heartfelt attempts to impede upon our civil liberty to keep and bear arms under the Second Amendment to the Bill of Rights. With that being said, I am going to speak about the Second Amendment in detail very briefly in hopes to educate many of you who may not be as educated as I have become after studying law for over 20 years of my life. With that being said, let's talk about the Second Amendment to the Bill of Rights. The way we can give everybody a little bit more clarity on what that specific amendment actually means, as opposed to what those in civil service have interpreted it to mean, in which interpretation has been accepted by many civilians who did not know that by accepting a bogus interpretation of the Second Amendment, that it would eventually put those in public office in a position to impede upon the freedom that we have to keep and bear arms, as we have been seeing in recent times, more notably what has transpired or what is currently transpiring in the state of Virginia. Okay, Second Amendment. Let's talk about that. We all know that the Second Amendment to the Bill of Rights, not a constitutional right, a civil right under the Bill of Rights. The Second Amendment to the Bill of Rights says, and I quote, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed," end quote. That is the totality of the amendment, as was ratified in the year of 1791. There are key words within the Second Amendment that I believe many of us have not grasped the realization of. And of course, those are the term keep, bear, arms, and infringed. So we're going to talk about those particular words and the definitions of those particular words to give us better meaning of what the Second Amendment to the Bill of Rights actually entails. First word I'm going to address is the word keep. For those of you who are unfamiliar with the definition of keep, I am going to quote the definition out of the Webster's Collegiate Dictionary, 10th edition. And that particular definition under that specific dictionary can be found on page 99. No, let me backtrack. It can be found on the page 637. The definition of keep is, and I quote, "to refrain from revealing," end quote. If we refrain from revealing a firearm that we have on our person, that essentially means that we are concealing that specific firearm. So if we have a right under the Second Amendment to the Bill of Rights, which is under Article 6 governing the Constitution for the United States of America, considered to be the supreme law of this nation, that means that we do not need permission from some person in civil service to exercise our right to conceal the weapons that we choose to own for our own personal protection. Oh, Chase, I'm reading the definition of keep out of the Merriam-Webster's Collegiate Dictionary, found on page 637, as that definition relates or equates to the meaning of what the Second Amendment to the Bill of Rights actually entails. The second word found under the Second Amendment to the Bill of Rights is bear. Under the same dictionary, but on page 99, the definition of bear is defined as, and I quote, "to carry or possess arms," end quote. Note that that particular definition did not indicate the term refrain. So we can surmise from the definition of bear as depicted in the Merriam-Webster's Collegiate Dictionary as associated with the Second Amendment to the Bill of Rights is that we too have a right to openly carry the firearms that we choose to own. Which means we do not need a freaking permit. We do not need a gun license, which is what people have dubbed that to be in violation of the Second Amendment, of course. But we do not need anyone's permission, especially those in civil service whom we have placed there to protect this specific right from enemies, both foreign and domestic. The third word is infringed. The definition of infringe as found under the same dictionary, but on page 599, defines the word infringe as, and I quote, how you doing? To encroach upon in a way that violates law or the rights of another, end quote. That is the definition of infringed, okay? So when members of Congress, to include state legislators, presidents, governors, judges, prosecuting attorneys, law enforcement personnel, when they have enacted, enforced, and applied acts of gun control, they were in violation of the law, as that law pertains to the Second Amendment to the Bill of Rights, because the definition of infringe specifically entails that they did not have the authority under the Constitution to make laws that would infringe upon the right that we have to keep and bear arms. Fourth word is arm. And this is a more interesting word that many people have not grasped the realization of. The definition of arm is found under the same dictionary, which is the Merriam-Webster's Collegiate Dictionary, 10th edition, defines that word on page 62 as, and I quote, weapons, end quote. So weapons is synonymous with arm or arms as depicted under the Second Amendment to the Bill of Rights. How you doing? Knowing that weapons equates to arm or arms, the next definition that I'm going to go to in order to clarify what arms really means is, of course, weapons. And the definition of weapon as found in the Black's Law Dictionary, 9th edition, on page 1730, defines the word weapon as, and I quote, an instrument used or designed to be used to injure or kill someone, end quote. That is the definition of arm. Which leads me to this particular point. We all heard, and I'm pretty sure every one of us have, how those in the legislative branches of our national or centralized government of whatever state we all live in have concocted laws that claim that we as civilians do not have a right to own certain arms. Amongst those weapons are machine guns. For example, Glock 17s attached with Sears, aka switches, which makes the Glock fully automatic. Would that particular gun outfitted with that specific device not be considered an arm by definition under the Second Amendment to the Bill of Rights? How you doing, Timothy? The answer to that question is yes, because a Glock 17 or any Glock for that matter, regardless of whatever model it is, regardless of whatever caliber it is, it can be used to injure or kill someone, just as well as a slingshot, just as well as this pledged bottle or container right here can be used to kill someone. So this right here is legally defined as an arm if utilized for that purpose. To make a long story short, based upon the Second Amendment to the Bill of Rights, every one of us have a liberty to bear whatever arm we choose to bear. So all of my brothers and sisters in Chicago, when they tell you you cannot have a Glock 17 outfitted with a freaking seer, aka switch, they are dead wrong. They are in violation of the law as that law pertains to you exercising that right. Now, what you do with that firearm after you have obtained it will determine if you then become a lawbreaker or not. There's nothing illegal about any one of us having machine guns, sawed-off shotguns that they have declared to be weapons of mass destruction, all that bullcrap that these dummies in civil service have placed upon our liberties, in which we place them in positions of public trust to protect and defend. They have utterly failed in that endeavor. And then they got the nerve to say that we owe them money through tax dollars. We don't owe them dummies nothing. They haven't earned a freaking paycheck. They haven't carried out their duties that they had taken an oath before us under God to carry out. I've established that the Second Amendment to the Bill of Rights enables every one of us to have whatever gun we want. I wouldn't mind having a Glock 18C, to be honest. Matter of fact, I would like 2 of them. That'd be what they call my EDC, or everyday carry, because it can switch from semi-automatic to fully automatic. You never know what type of people you may encounter in this world today. Heck, if it's one person that I'm confronted by with ill intent, I can keep the Glock 18C on semi-auto. But if it's a group of people armed with AR-15s and Glocks with switches, of course I'm a switch that selected the full auto, because that'll be the best chance that I have to protect my right to life and, of course, liberty, in addition to security of person. Let's go deeper into this particular amendment. When you look at the case established in the Supreme Court for the United States, known as McDonald versus City of Chicago, kind of ironic that I'm talking about the brothers and sisters in Chicago having Glocks of switches, aka seers, or also known as seers. And I'm mentioning a Supreme Court case that was handed down on account of what happened in the city of Chicago. But McDonald versus City of Chicago, citation number 561 U.S. 742. This case was written in the year of 2010. Or the opinion in this case was written in the year of 2010, to be more specific or politically correct. On page 768 to that specific judicial decision, the judges of the Supreme Court for the United States said, and I quote, "The right to keep and bear arms was considered no less fundamental by those who drafted and ratified the Bill of Rights," end quote. That case, from what we have just seen, for those of us who didn't know before this live stream was conducted, entails that the right to keep and bear arms is a fundamental right. We know it's a fundamental right. Now, what Andrew P. Napolitano said in his book, titled, "It is Dangerous to Be Right When the Government is Wrong, the Case for Personal Freedom," which was published by Thomas Nelson Incorporated in the year of 2011. On page 121 to Judge Napolitano's book, and of course, he's a federal court judge, y'all. He said, and I quote, "What the government ignores is that our right to keep and bear arms is a natural or fundamental right," end quote. When you look up the definition of natural right in the Black's Law's dictionary, it will lead you to look up the definition of fundamental right, which means that both of those freedoms are synonymous, or the words So a natural right is a fundamental right, and a fundamental right is associated with a natural right. So it is clear that the Second Amendment liberty that we have to keep and bear arms is a fundamental right. Follow me on this. One of the things that I noticed when studying law for as long as I have, I've come across many cases, y'all, cases that many of you have not even been privy to. Not because you don't want to know about judicial decisions that can actually support whatever argument you bring to the forefront of one's attention in the society that we live in. It's because many people did not have the time to study law. Many people had to work for a living. People have families that they need to tend to. So people don't have the time in a 24-hour day to study law and also take care of other business that they had to take care of. I was able to study law on account of that education being paid for or funded by tax dollars, people like you. Because of that, I feel it is my duty and responsibility as a man, as a fellow citizen of America, as a human being, as a child of God, to convey the information that I have accrued over the years through studying, which was made possible because of people like you. That is the reason why I'm here on YouTube conducting this live stream on this matter right here and right now. Okay. The McDonald case says that the right to keep and bear arms is a fundamental right. But what does the judges say about legislators infringing upon our fundamental rights? Do members of Congress have a right to make laws that violate our fundamental right to keep and bear arms? Does legislators within the General Assembly of a specific state, do they have the authority under the Constitution to create laws that restrict our fundamental rights? The answer to that question is found in the case of West Virginia State Board of Education versus Barnett. Citation number 319 U.S. 624. This case comes out of the Supreme Court for the United States, as well as the McDonald decision that I just previously read. And the Barnett case was handed down in the year of 1943. On page 638 to that specific judicial decision, the Tribunal of the Supreme Court for the United States said, and I quote, "The very purpose of the Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities and officials, and to be established as legal principles to be applied by the courts. One's right to life, liberty, and property, to free speech, a free press, freedom of worship and assembly, and other fundamental rights may not be submitted to vote. They depend on the outcome of no elections." End quote. The Barnett case specifically says that the fundamental right to keep and bear arms is outside the purview of majorities and officials. We all know that officials is equated with those who have been elected or appointed to positions of public trust, governmental positions, such as the president for the United States, a governor of a respective state, members of the General Assembly who are considered the legislative body of a specific state, members of Congress, Supreme Court judges, inferior court judges, state court judges, jurors, which also equates to civilians. Nobody has any authority to make laws, to establish rules, regulations, executive orders, judicial decisions, policies that infringes upon the right that we have to keep and bear arms. I don't give a crap what people think about people who exercise that freedom. It is irrelevant because the law is the freaking law, right? Is that not what they tell us? So I'm simply saying, under equal protection of the law, those in civil service, to include civilians who believe in the fallacy that has been orchestrated by those in civil service, to give the same respect to people like me amongst other civilians. What happens when a law, or what happens before a law is enacted in a legislative body, whether that be national or state? I'm going to tell you all what happens. A member of Congress creates a law in which they write on paper based upon what they feel should happen in the society that we live in. They file that particular paperwork with the congressional body. The congressional body then sets up a meeting in the chambers to vote on whether or not they agree with the bill or the contents of the bill in order to make that bill law. What happens in the process of them doing that? When they say yay or nay to the question of whether or not they want that bill to move forward, what are they doing, y'all? I'm going to tell you what they're doing. They are voting on a bill in order to make that bill, by the majority of those so-called officials in the congressional body, to become law. What does the Supreme Court judges say about them making laws that violates fundamental rights, specifically the right to keep and bear arms, in which we now know, for those of us who did not, is considered a fundamental right? The judges said fundamental rights may not be submitted to vote. They depend on the outcome of no elections. So what the heck are members of Congress doing? What the heck are those legislators in the state of Virginia doing right now as I freaking speak? They are not only in breach of the Second Amendment to the Bill of Rights, which is considered the supreme law of the land, they are also in breach of Supreme Court precedent, which has conceded with the argument made by you and I to compel them to rule in accordance to the way that they have ruled. So it is not us that are violating the law when we choose to exercise specific civil, constitutional, and human rights. Because to exercise a right that is protected by law, that means that we are, in essence, law-abiding citizens, because we are doing what the law permits us to do. Those in civil service, to include other civilians who have adopted the propaganda of those in civil service, who choose to ignore our civil and constitutional rights protected under the supreme law of the land, they are the actual felons or criminals, because they're the ones in breach of the law designed to respect those freedoms, that specific freedom in general, in which we have a right to exercise on an individual basis. A lot of people equate the Second Amendment right to keep and bear arms with a constitutional right. That is untrue, but because people equate that right as being a constitutional right, let me read yet another Supreme Court precedent to you all that substantiates or correlates with what I just said earlier. That case is Lucas versus 44th General Assembly of the State of Colorado, citation number 377 U.S. 713. This case was written in the year of 1964. On page 736 through 37 to that specific judicial decision, the judges of the Supreme Court said, and I quote, "A citizen's constitutional rights can hardly be infringed simply because a majority of the people choose that it be," end quote. It doesn't matter what the majority of you all feel about certain individuals here in America exercising their right to keep and bear arms, because that right is not predicated on what you feel. It's not predicated on what anyone believes. Again, It is no crime to exercise one's right to keep and bear arms. When I say arms, I'm talking about all arms. You can have a missile launcher, a grenade launcher, a fully automatic machine gun, a fully automatic shotgun. That is the definition of arm as defined under the Second Amendment to the Bill of Rights. That is a fact that none of us can get around, in spite of what we feel, in spite of what we think. If I saw a man or woman in society right now with a fully automatic machine gun on their person, it will not cause me any freaking alarm. It will not cause me any more alarm than if I seen a freaking police officer or someone within the military walking the streets with those type of weapons. In fact, I may be a little bit more alarmed if I see a police officer or a member of the military with those type of arms in the society that we live in before I look at another civilian in that same light or in a negative light. There's so much, y'all, about the Second Amendment to the Bill of Rights that many of you do not know about. And that is why I am going to stay here on YouTube and I am going to constantly reiterate what it is that I've said. In fact, this weekend, Saturday to be specific, because I don't think many people are going to be up when I get off work on Friday morning at like 2 a.m. So on Saturday, I'm going to come back here and I'm going to do an in-depth live stream on the Second Amendment liberty to keep and bear arms. That way, if you hear it, it's fine. If you don't hear the live stream, if you're unable to make it at that particular time, you can always go back on my YouTube page and look at the video then, or the video of the live stream, and utilize the information that I'm giving you all to overcome the obstacles in which those in civil service are constantly attempting to throw in our path, as if we're just going to bow down like many people have done in the past. Many of us are getting fed up with that nonsense because their actions are not keeping us safe. That's just the fact of the matter. They're not doing anything to keep us safe. They want to disarm the people, which is something that they cannot do legally. And if they are criminals, what the heck are we even doing listening to criminals? Should we not be exercising our civil right to subject them dummies to a citizen's arrest? Just a thought that we will dwell more into this weekend, y'all. But with that being said, you all stay safe and have a good day. And marinate on what I said here today. That way, if you have any questions on Saturday, by all means, feel free to convey those questions to me so I can give you a legitimized answer associated specifically with the law. Have a good day, y'all. And I appreciate y'all coming through.